Great. So thanks everybody for coming. It's really a pleasure to welcome you here and to welcome Dan Schwartz to the New Ideas in Insurance webinar series. Dan's day job is as the Frederickson and Byron Professor of Law at the University of Minnesota Law School. And between teaching contracts and insurance and a lot of other stuff, he is one of the most prolific and original young scholars in insurance law in the US. And I would put young in quotes, except that he recently in 2017 won the ALI Young Scholars Award. So he's officially young, and I don't have to put that in quotes. Dan has written about a wide range of topics in the management and allocation of risk. His work on systemic risk and its regulation is groundbreaking, and he's recently produced a major paper arguing that much of the way states regulate insurance is actually unconstitutional under state constitutions because it delegates too much authority to the NEIC. He's also written on micro-level questions in insurance, including issues of discrimination and consumer protection and competition. And his work is always characterized by careful attention to theory, to legal doctrine, and to the nitty-gritty details of institutional and contractual design. Today's paper on medical necessity is no exception to that. So I will ask you to join me in welcoming Dan. We're going to hold the questions until he's done, unless you have clarifying questions, but otherwise we will just use the raise hand feature in the WebEx thing, and we'll call on you, and we look forward to a great paper and a great discussion. Thanks, Dan.
Thanks so much, Peter. And I can't help but preface my comments with two thoughts relating to your introductory remarks. The first being that they actually changed the name of that award after I won it from the Young Scholars to the Early Career Scholars, presumably because I did not qualify as young. And second, if I am in fact young, I'm not sure, you may have a vested interest in telling everyone that I'm young, because one thing people may not know is that Peter Siegelman was my college econ professor back in the day when I was at Amherst College, and he was my visiting, he was a visiting professor there. So so don't believe his characterization of me as young. So with that, I'm really excited to be here. That so many this is, you know, one great benefit of living through a pandemic, I suppose, is being able to share my work with so many people across the country. And this work really is new. This is actually the very first time I'm presenting it. It's a paper that I just put on SSRN a week and a half ago, and the link is there. And of course, you're all free to download it as many times as you would like. But it's actually a paper I'm pretty excited about. And it's a paper, of course, importantly, that's co-authored with my colleague, Amy Monahan. So with that, let me just try to get right to it. Let's see here. Okay. So the first sort of thing to understand about what this paper does is it starts out trying to characterize historically how health insurance policies have been structured. And historically, what we argue, and I think this is pretty well accepted, is there really are sort of two types of coverage exclusions in health insurance policies historically, right? So the first is traditionally health insurance policies would have, you know, a bunch of what we call categorical coverage exclusions. And what these were statements like, we just don't cover X service or Y service or Z service. And they had a variety of different, you know, rationales to them. Maybe we don't want to cover a cosmetic surgery because of potential moral hazard, and it's not, you know, it's something you should pay for out of your pocket. Or it's, you know, or we don't want to cover, we don't want to cover, say fertility treatment or whatever else. So it was sort of categorical, and the key feature of them was that it wasn't really meant to customize coverage to particular insurers or non-insurers. It was just, we don't cover this service. But then they had a second sort of type of exclusion, and these exclusions were characterized by broad standards. So what health insurance policies would say is we don't cover services that are not medically necessary or experimental. And almost always they use these terms. Sometimes instead of experimental, they might have said investigative, but these were really terms of art. And generally, the way that health insurance policies defined these terms, they used broad standards. And so, you know, I mean to be referencing sort of, you know, very lengthy distinction in legal scholarship between standards and rules, right? And standards are, you know, principles that try to leave a lot of discretion to the decision maker and not to specify in advance exactly how the rule should be applied in every circumstance. And so the sort of traditional, illustration of what a standard is versus a rule is a standard is drive safely or drive reasonably under the circumstances, where a rule is don't drive more than 70 miles per hour. And there are various sort of well-known trade-offs between standards and rules, but historically, health insurance policies used more standard-like language to define these concepts. And so here are a few examples, and you can see that these, qualify as standards because they require a lot of discretion to apply, right? Whether or not care was medically necessary under this standard would require someone with expertise in medicine to look at a particular case, consider all of the circumstances, and make a judgment. And even though there are certain, parameters, given about, well, is this, similar, is this consistent with generally accepted practice parameters? There's a lot of discretion, right? So the language might vary. Certainly there wasn't a uniform definition of medically necessary in health insurance policies or a uniform definition of experimental, but in general, for most of our history, health insurance policies used broad standards, and there's a reason for that. The idea was, look, at the end of the day, the job of being a doctor is not like a mechanical job, right? It's a job that requires attending to the unique circumstances of every patient and deciding what treatment is medically appropriate for what patients and has enough scientific background for a particular patient in a particular circumstance. It can't be reduced to cookbook medicine, right? And so this was meant to sort of reflect the fact that medicine was generally viewed as sufficiently complicated that there was no way to sort of reduce what was medically appropriate or scientifically appropriate to sort of specific rules. Okay, so this is historically how health insurance policies have been structured. Okay, so what we try to show in our paper is that standard or that a structure is really changing. Okay, and we do so by sort of creating this new category we call rules of medical necessity. And here's our definition, but the basic idea of a rule of medical necessity is that unlike our traditional categorical coverage exclusion, which just says we don't cover X treatment, we don't cover Y treatment, a rule of medical necessity is one that limits the availability of health care to some policyholders in some circumstances, okay, based on a judgment about its medical and scientific appropriateness, okay? So that's a rule of medical necessity. And traditionally, we didn't have those in health insurance policies. But what we explain is increasingly that's not true, okay? And there are a variety of ways in which health insurers have started to include rules of medical necessity in their health insurance policies. So one mechanism that is becoming more and more common is so-called incorporation by reference of medical policies. So what you'll see, for instance, is something like this. For a specific type of care, and again, all the examples here, there's examples, but they're real examples from real insurance policies, would say something like, well, we will only cover particular treatment if it meets our medical coverage criteria, and this will be within the insurance policy. And so here we have a incorporation by reference, and the medical coverage criteria, arguably, then becomes part of the contractual provision because it's incorporated by reference into the contract, okay? But you also see much broader strategies here. So here's another example, okay, where we have some insurers out there that say, look, if a service or a supply is not medically necessary according to one of our published medical criteria, we will not pay for it. So what's the difference? This is for a specific type of medical care, and this is for all medical care. But the thing to realize is, what are these medical coverage criteria? These are immensely lengthy, complicated, statute-like criteria that cover just an immense range of medical care. So here's an example, just another example from a medical policy about proton beam radiation therapy, which is often disputed whether or not it's medically necessary. And you can see sort of the type of specificity you can get in these medical criteria. But I actually thought it would be useful, and let's see if this works. Okay, just to go to Blue Cross Blue Shield of Minnesota and just to look at their medical policies, which are incorporated by reference in certain Blue Cross policies, right? So let's go to medicine, okay, and click on medicine. Oh, is this going to work? Oh, well, it's not letting me. For some reason, this isn't working. I don't know why. Here, let's see if I can do it like this. I think it might be because I tried to link to it directly without agreeing to your terms of service. So I just want, because I think it's important for you to yeah, so here. So first you have to, before you get there, you have to agree to all of this. So I'm gonna carefully read it and accept. And now I think I'm here. Okay, so here are all the medical policies. And let's see. Well, now I'm having some. Oh, here we go. Here are the medical policies. Okay, now let's see if it lets me do this. Oh, no, it's not. Well, here. Let's see if this works. Okay. Well, technical difficulties, but if I weren't having these technical difficulties, you would see that there are hundreds of these for all sorts of different medical policies, and they are immensely detailed. Okay, let me try one other. Let's try just a different insurer. Medical policies.
Hey, Professor Schwartz, it's Mike from IT. I believe you're probably just sharing PowerPoint right now, but if you share your screen, you should be able to share. So you'll just have to unshare right now and then reshare, but share your screen instead. And then when you click on the link,
exactly. I was assuming that you all could see what I was. Where's? Let me come to this. Okay, hold on. My apologies. Now having. Where's? You're sharing Microsoft Power. I can't. Oh wait, hold on. So I unshare.
Yep.
How do I unshare?
I think it's stop sharing is the.
Oh, stop sharing. Okay, hold on.
Yep.
Okay.
And then when you do share again, just make sure you're sharing your screen instead.
Ah, okay. There we go. Okay.
And then when you click on links and things like that, it should pop up. Yep.
All right, good. So here's just Medica. That's actually my insurer. And you can start seeing their coverage policies in alphabetical order. Okay. So here are all their coverage policies, and we can just click one so you can see, you know, what these actually say. And now I can't see my mouse. Okay. And you can see how specific they are, right? And they'll have very detailed provisions about what's covered and what's not. Oh, no, I'm now actually having some trouble. So I'm going to go back over here. The point is that there are a lot of very specific language that's incorporated by reference via the medical policies. Now, there are other strategies, too, that insurers use, health insurers are increasingly using, to bring rules of medical necessity directly into their insurance policies. So another example, sometimes instead of incorporating by reference medical policies, they'll just put these rules of medical necessity directly into the insurance policy. So again, here's an example of just a term in an insurance policy. And you can see this qualifies as a rule of medical necessity because surgical treatment of obesity is covered, but it's only covered if you meet specific criteria, i.e. you have a BMI of greater than 35 with complicating coexisting medical conditions or diseases. A third strategy that is increasingly being found in health insurance policies is this. And this type of language doesn't actually attempt to make rules of medical necessity part of the insurance policy. They instead merely authorize the development of these, okay? So these are a variety of different strategies. And one of the things sort of I think that's important to know is, okay, well, how pervasive are these? So it's hard to get a perfect count, but we tried to get some basic information on that. And the way we did it is if you're a health insurer operating in individual market, and usually in most states in small group and large group markets, any insurance policy you sell has to be filed with a state regulator. So what we did, and most states actually make these publicly available. So what we did is we just started going through the states and picking out the 3 top health insurers in each of the 3 main markets: individual market, small group market, and large group market, and then just looking at their insurance policies. And the first thing we tried to do is just characterize them using these basic criteria, right? Do you have no ruleification of medical necessity in your policy? Procedural ruleification, meaning you say you do it, but you don't make them part of your policy. Some ruleification, meaning you do it for specific subtypes of care, or extensive ruleification, meaning that you attempt to incorporate by reference all of your medical policies into your insurance policy. And so here's what we found. Now, I should say, for one thing, that this count is still ongoing. We've gone through more than half the states. We haven't gone through all of them. So but we have over 100 insurance policies coded. And what you'll see here is roughly a third of them attempt to incorporate all medical care, all medical policies into their policies in a manner that's akin to this. And then almost all of the remainder have some ruleification of medical necessity, either through an example like this or an example like this, where they're picking out particular forms of treatment and rulifying when it is medically necessary. Okay, so again, this is preliminary. And the other thing I should say is that there are always some edge cases about how you code things. So I don't want to pretend that this is exactly precisely accurate, but I think what this definitely does is it gives you a sense of how pervasive this is becoming. And the other thing I'll say is that the trend, certainly in this category, has been to increase this over time. We've seen a lot of insurers in recent years put in these types of terms. To give you a little bit more of a sense, we tried to break this category down. Okay, this is just some ruleification, how much? So we tried to actually quantify it here, and you'll see it's really variable. But there are a lot of insurers out there who have 9 or 10 different types of care that are subject to this, whether it's weight loss surgery, whether it's organ transplants, what have you. It's sort of all over the map. Okay, so what can we say? I think we can confidently say this is happening. We can confidently say this is a very real thing and it's a pervasive thing, and it appears to be an increasing trend, especially since historically we didn't really see any of this. Okay, so why am I telling you all this? Why does this matter, right? What's your point, Schwartz? Is this just all like, me talking about how insurance policies are structured? No. It turns out that we think this has really important normative implications about how the law works. And so I want to talk about 4 fundamental ways that the law seeks to deal with, a very sort of clear issue in all of insurance law, which is making sure that insurers are paying claims that they should pay, right? And how that is worked out in different areas of the law, different areas of insurance is different, right? In property casualty, we have, bad faith law, and we have coverage litigation, we have complaints. But in health insurance, there are a variety of tools that are really sort of important and pervasive to try to achieve this goal. So the first is internal review. So every insurer has to offer, and this is, there are various different laws that achieve this, whether it's ERISA or whether it's a state insurance law. It's going to depend because of how fragmented our healthcare system is. But every insurer, either under state law or federal law, has to provide a mechanism for so-called internal review. So if they deny coverage to you because of a medical judgment, and this is from the ERISA implementing language, if they make a judgment based in whole or in part on medical judgment, then you have a right to appeal that judgment within the insurer to a healthcare professional who has appropriate training and experience in the field. And the basic idea here is, I think, relatively straightforward, which is, look, and it's relatively straightforward if we think about historical context in which these rules are adopted. If a health insurer decides maybe, 3 days in the hospital is too much and you only need 2 days, only 2 days are medically necessary, and you think that's wrong, you can go and sort of talk to someone else at the health insurer, and they have to consult with a doctor who has real expertise in this area and explain to them why, in fact, you really need 3. So it's meant to be a check against the abuse of medical judgment or the incorrect assessment of medical judgment. But here's the problem. Once the structure of health insurance policies moves from the traditional standard to a rule, all of a sudden it fundamentally changes the meaning of internal review. Why is that? Well, because now the only question during internal review is whether or not the insurer correctly applied its rules of medical necessity. And oftentimes, this actually isn't a medical judgment at all. It's actually more of a lawyerly judgment. You look at the rule, and it says you only get 2 days of treatment for XYZ, 2 days of hospital stay for XYZ medical condition and ABC circumstances, and you make sure that you have that, and then you're done. And so it's a matter of making sure the rule was properly applied. What does that mean? It means that, for one thing, the insurer doesn't even have to use a medical expert to decide whether or not it properly denied claim. And it means, for another thing, that there's no opportunity to explain, well, that rule doesn't apply in my case. Here's why, right? There's no opportunity to challenge the medical judgment that was embedded within the rule, because all the insurer has to do under the regulations is make sure that it applied the rule. This, by the way, applies even if the insurer, this is true, even if the insurer doesn't incorporate its rules of medical necessity into its insurance policy. Even then, many times insurers are just denying internal reviews based on their medical policies. And so the effect is that you're not actually getting what internal review was meant to get you, which is a chance to explain why your medical condition requires certain types of care. That's not the question an insurer has to ask anymore because of its change in contractual structure. Even if the insurer's rule does, so sometimes insurers' rules of medical necessity do require the application of some medical judgment, right? Like the BMI one doesn't, but sometimes the rule of medical necessity might actually, say something like you can only get this treatment if you have, excessive risk of comorbidities or something like that, right? But even then, the rule of medical necessity constrains the medical judgment that can be used by the internal reviewer and doesn't allow them to consider the full host of factors that might be relevant. And so you lose the opportunity to explain why your case is different. Okay, next, a really important protection, and the Affordable Care Act made sure that this protection applies to all insurers across the country, is external review. If your internal review isn't successful, so long as the insurer is denying coverage based on a medical judgment, you have a right to have an external reviewer, which is an independent third party, and there are companies that supply these services, evaluate whether or not the medical judgment of the insurer was correct. And again, the goal here, of course, is to make sure that people have access to medically necessary care. But because external review was developed back in the day when we didn't really have rules of medical necessity, and insurance policies generally covered medically necessary non-experimental care, virtually all statute, and this is very complicated, so I'm going to have to refer you to the paper because the rules that apply for external review are very fragmented. But what the Affordable Care Act essentially did is it said states had to at least use the rules that are consistent with the NAIC's model, but then there are different rules for self-insured. But by and large, what the rules governing external review say is that external reviewers do not have the power to require an insurer to provide coverage if their plan documents do not provide coverage. So what does this mean? This means that essentially your right to external review is meaningless if there is a rule of medical necessity that is part of your insurance contract, either incorporated by reference or included directly therein, because the external reviewer does not have the power to say that that treatment is medically necessary, even if they believe it's medically necessary, because they're bound by the terms of the insurance policy. Now, there are a few settings in which this isn't true. So actually, there's an interesting Minnesota Supreme Court decision that interprets Minnesota's laws to allow external reviewers to grant coverage even when the insurance policy says otherwise. But that's the exception that proves the rule. By and large, external reviewers do not have the power to require an insurer to provide coverage if it's clear in their policy that that doesn't say it. Now, understand how different that rule is given sort of the historical structure of insurance policies relative to the current structure, and recognize that the current structure effectively fundamentally changes the meaning of this external review so that it can no longer be assured that if a doctor just deems that care that your providing doctor has recommended is medically necessary, they can grant it. In fact, it's even worse than that, because in many cases, you might not even be able to get to external review. The trigger for external review is that there has to be a dispute that requires the clinical judgment. And again, it's very complicated who makes this determination. Sometimes it's the insurance commissioner, sometimes it's the health insurer, sometimes it's the external reviewer. But you can understand how if the rule of medical necessity in your insurance policy is, well, you don't get an organ transplant unless you have A, B, C, D criteria, and there's no doubt that you don't have A, B, C, D criteria, then there's no clinical judgment to be exercised. So you might not even have the capacity to challenge that rule of medical necessity in external review. The problems persist in litigation. Another intended safeguard against the risk that your insurer is excessively restricting the availability of medically necessary care. You can either sue that insurer under contract law or ERISA, depending on whether or not it's an employer-sponsored plan. But insurers move to incorporate rules of medical necessity into their insurance policies fundamentally changes the nature of this cause of action. So the analysis depends a lot on whether or not we're dealing with deferential review or de novo review. If you're going through ERISA, usually it's going to be deferential review. And if you're bringing an ERISA cause of action, what most courts do, and again, we have a lengthy discussion of this in the paper, is they say, look, if an insurer has all these medical policies that they've developed and they're just applying those medical policies, that is their application of their discretion. And so you lose because they are applying their medical judgments based upon these, by the very fact that they have drafted these rules. And so it doesn't even matter in this case whether or not the rules are formally made part of your health plan. Automatically you lose if the insurer is relying on them. Now, I'm not sure that's so different than the result we would get even without rules of medical necessity, but it is notable that, again, there's not really this safeguard or this check that these rules are appropriate. The problem is, I think, easier to see when we're looking at de novo review, where there's no deference, and this is usually going to be true under state contract law. And here, what we see is increasingly cases say, well, look, if it's part of your formal contract, there's nothing I can do. Your insurance policy says we don't cover obesity surgery if you have had a BMI of less than 40 in the last year, and you haven't gotten that. I mean, end of discussion, right? That's what the contract says. We have to apply the plain meaning of the contract. And again, the way that the insurance policy is structured, there's no basis for you to argue to a court that the rules of medical necessity are not advisable from a medical perspective or a science. That's just not relevant. Okay? So once again, the assumption that these litigation provides some check against an insurer adopting rules that are excessively restrictive just doesn't hold true. Now, it's a slightly different point to understand this in the context. No, I should say one other thing. This result really does offend a lot of state courts, and so sometimes they try to find ways around it. So the most common way that courts try to find a way around this is by saying that the insurance policy's incorporation by reference of its medical policies wasn't clear enough. Okay, and I think what's notable about this is how easy it is for insurers to get around this. Okay, all they have to do, even under this logic, is just make their reference, their incorporation by reference of their rules of medical necessity of their medical policies more explicit in their policies. And one of the things that we've seen is that insurers are getting better and better about being really clear about this in their insurance policy, that they will not pay if their medical policies don't provide coverage, and providing notice and allowing people to access them and saying, here's where you get them, so that they formally become part of the contract. So this is a real Band-Aid, and I think it's notable that, this is essentially the last real power that courts have, because at the end of the day, the courts don't have the power to say, we're not going to enforce that contract because we don't like it. Okay. How else does the ruleification of medical necessity fundamentally change the way that the law operates? Well, it's also true in the context of mandated benefits. So I think the story here is a little bit different, but recognize that there are a ton of mandated benefits that health insurers, first, Obamacare requires essential health benefits. Lots of states have mandates, and these mandates are in part meant to make sure that insurers are covering things that we think they ought to cover that are medically necessary. But it turns out rules of medical necessity can also be really distortive of coverage mandates. So a lot of this depends on how the mandate is structured. But if you think first about what mandates can really be manipulated by rules of medical necessity, the best example are actually the essential health benefits in Obamacare. So the way that these work is they require insurers to cover certain categories of care, and there are like 10 different categories, okay? But all that's required is you cover these different categories, and there's a complicated mechanism for determining which categories they are based on the states. I'm not going to get into the details. Again, the details are in the paper. But it's very clear that insurers can use rules of medical necessity to restrict access to these essential health benefits. And in fact, they've done so. So for instance, one essential health benefit is that you have to provide hepatitis C drugs, which are these new classes of hepatitis C drugs that are very, very expensive. And you have to provide them if you're providing essential health benefits. But some insurers use rules of medical necessity to very much restrict access to them. So they'll say, well, these hepatitis C drugs are not medically necessary unless you've been clean and sober for a year. They're not medically necessary unless you've tried 3 others and they don't work. And they're not medically necessary unless you have ABC form of hepatitis. Okay. And so the actual way these essential health benefits get implemented by insurers are incredibly different and can be manipulated by insurers adopting these rules of medical necessity to limit access. This is true actually also for other mandates too. So many mandates at the state level have the structure. They'll say the insurer has to cover medically necessary whatever, medically necessary rehabilitation services, or a common state mandate is habilitative services for autism. Okay. But then what does medically necessary mean? It's not defined by the statute. So insurers can then say, okay, well, we're going to interpret the statute, and they can adopt rules of medical necessity that have really different implications in terms of the availability. Well, habilitative services for autism mean this, and they're only necessary if you have this type of autism in this type of case, and so forth and so on. And so they can really distort the meaning of these mandates in a way that has profound implications for practically their availability. This is even true, by the way, if the statute tries to define medical necessity, but just uses a broad standard. Now, there are other mandates that are actually very resistant to this type of manipulation. And so here are some examples. There are a few state mandates that say specifically that if a treating physician recommends a mandated benefit, it has to be provided. And effectively, what this does is it requires an insurer to follow the rule that something is medically necessary if a treating physician says it's medically necessary. The other approach that some state mandates use is to say that you have to cover a mandated benefit if it is medically necessary as determined by the rules of some specific medical association. So actually, there are a number of state mandates regarding inpatient drug rehabilitation that say that health insurers have to follow the rules for whether those are medically necessary that are adopted by, I forget the organization, but it's the Association of Behavioral Health Doctors, and they've published criteria, and you have to use those criteria. Okay, so where are we? I think hopefully what I've tried to convince you of is that if you go all the way back to the classic structure of health insurance contracts and the setting in which all of these ways to constrain health insurers, internal review, external review, litigation, mandated benefits worked, the idea was that in general, we're going to make sure that health insurers cover things that are medically appropriate. And we're going to have safeguards against them essentially restricting what they cover to pad their bottom line, right? The less they cover, the more they'll make in the short run. And we don't want insurers, health insurers, to be restricting access to medically appropriate care because of their bottom line. We want people to get that medically appropriate care. And so based on this contractual structure, all of these tools were developed: internal review, external review, coverage litigation, ERISA litigation, coverage mandates, and all of them basically had the effect I just described. But when we start looking at the new reality of what health insurance policies look like, the meaning and the protection that the law provides is radically changed. And there's essentially no meaningful protection against the risk that insurers will draft rules of medical necessity and put them into their contracts that restrict access to medically necessary care because it's more affordable to do so. Can't do it through internal review, can't do it through external review, can't do it through litigation, can't do it through coverage mandates. So what are the solutions? Because we always have to have solutions. Well, it turns out the solutions are difficult, and we don't want to say we have the solution. So instead, what we do is we say, look, there are a variety of potential ways you can think about trying to respond to this reality that insurers are changing their contracts in ways that dramatically impact the risk of unfair coverage denials. But here are a few. So one is there actually are a number of state laws governing utilization review. But these state laws are really targeted at the process of utilization review because, of course, utilization review has been around forever. That's how insurers would decide whether or not something was medically necessary or not. So there are all these rules in there about, okay, well, you have to have appropriate doctors making these determinations. You have to make a determination within a certain period of time, and there are these accrediting agencies, URAC, and I forget the other ones, and those are built on this. But these rules are based upon essentially regulating the procedures for making medical necessity determinations, when what's really needed is to regulate the substance of whether or not your rules of medical necessity that you adopt represent an appropriate trade-off between medical appropriateness and maybe cost, maybe not. I mean, that's a big debate, how much we should take into account cost. But right now, these rules basically don't govern rules of medical necessity at all, or say very little about rules of medical necessity because they're new. And also, it's very unclear to us, and this is a part something I think we need to research more, how effectively these are enforced. There's no private cause of action, and by and large, these seem to be enforced simply by delegating to these private accrediting agencies. And these private accrediting agencies, as far as we can tell, don't really constrain the rules of medical necessity that different insurers adopt. So one thing you could do is you could try to get at it through state laws. Now that actually doesn't really solve the problem by and large, because this would be preempted by ERISA for many health insurance plans. So you could try to do it at a federal level, but that would create its own problems. So there are issues here, but that's one option. You could try to create a private cause of action, but that has its own problems as well. A second solution is actually to borrow from the approach that's used in some mandates and to say, well, insurers, you can't come up with your own rules of medical necessity because you have an obvious conflict of interest, right? You're going to adopt rules that restrict access to care when it's really expensive, especially if you have any, plausible argument for doing so, and you're going to be too late to recognize, emerging evidence. So instead, we should require health insurers to use rules of medical necessity that are adopted by third parties. The difficulty here is, of course, which third parties, right? I mean, those might be biased as well. You could certainly imagine trying to say you should follow the rules that are adopted by an association of doctors. They're going to want to cover everything, even if there's, even if it's not clear what's medically necessary and what's not, even if arguably it's experimental. A more realistic approach, I think, actually would be to require insurers to follow the rules of medical necessity that Medicare uses. So Medicare has its own rules of medical necessity that it develops in a publicly available a book. I'm forgetting the name of the book off the top of my head. It's like a manual or something like that. It's lengthy and it's online. And we could just say, you have to follow the rules of Medicare. That might be a more palatable solution. Of course, there are obvious objections to that in terms of restricting freedom of contract, arguably, creating government death panels, right? We can imagine the arguments against that. So it's not clear to me that that would work either. A third approach, and this is the approach I actually favor, though I actually would do it a little bit differently than my colleague, my co-author Amy would do it. What I think makes a lot of sense is to allow insurers to use rules of medical necessity when they're processing initial claims. Because, going back to the sort of general literature on rules versus standards, rules, there's obvious case to be made for rules of medical necessity when you're processing initial claims. It makes things easier, it makes things more consistent, it makes things more predictable, and you need all of that when you have lots of initial claims. But it's much less clear to me that insurers should be allowed to just rely on their rules of medical necessity once you're dealing with an appeal. There are a lot fewer of those appeals. At that point, you have noticed that your rule of medical necessity is potentially problematic, maybe you're over-inclusive or under-inclusive. So at that point, you should be able to say, look, this rule isn't binding, and if this rule is, over-inclusive or under-inclusive or doesn't represent the latest science, then we can require coverage. So I would allow external reviewers to do that, and that basically essentially goes back to the Minnesota approach I mentioned earlier. I would allow courts to do that, and you could allow courts to do that by basically just having a mandate that all insurance policies have to cover medically necessary and experimental care. There might be some problems in implementing it with how would you deal with the sort of categorical coverage exclusions. So there are issues there, but I actually think this is the most promising approach personally. There's a question about whether or not how you would apply it with internal appeals. I actually would even say an insurer shouldn't be allowed to rely on its rule of medical necessity during an internal appeal. I would say if you're appealing it internally, the insurer should have to justify its rule of medical necessity and should actually have to question it. I'm not sure how much of a difference that would make, but to me, I do think logically that makes some sense. There are, of course, disclosure-oriented strategies, and I'm not going to get there are a lot of problems with this, but could it make an incremental benefit? I think so. A lot of rules of medical necessity aren't even publicly available, and even when they are publicly available, it's very hard to figure out when an insurer purports to make that binding and part of the contract and when it doesn't. So I could imagine having some, single clearinghouse where we put all these rules up there, and it makes it easier for people to say, oh, well, United Health has very restrictive rules on this versus that. That can make an incremental difference. Honestly, I'm pretty skeptical it would make a difference given, how little disclosure laws work, but could it make a little bit of a difference? Maybe. So those are my thoughts. That's the basic paper. I hope you're all still there. I think you are. And now I need to stop sharing my screen. Stop sharing. There we go. And I'm very happy to take questions. And I hope that this was an interesting presentation, even for those all the way in Israel where it's midnight.
Great. So Dan, do you want to just call on people? We can have this by raised hands. And I see Anya Prince has her hand up, so I'll call on her for the first one. But then Dan, why don't you take over after that?
Sure. Sounds good.
All right. And you can see who's got their hand raised?
I think so. Yes.
Yeah. Okay. Anya Prince, you're up.
All right. Hi. Thank you so much for that presentation. Super interesting. So one of my questions I had, and you kind of got to it with your solution that you like best, C, but it did strike me as maybe being helpful for people when they're shopping for insurance to actually have some rule-based disclosures. And so then I thought, so one question, my concrete question is, could you tell when these medical rules or the rules of medical necessity were set up, were they more preventive elective surgery or medical actions, or were they more emergency diagnostic? Because like the obesity one, maybe it's something that somebody could actively shop for an insurance during the open market, know exactly that they meet those medical necessity rules, and that could be beneficial. So I just wanted you to talk about that a little bit. Thank you.
Yeah, so I think this is a really good point. Like there are clearly benefits to rules of medical necessity, and so I don't think we want to be read as suggesting we should just completely get rid of them. And I think one of the benefits is to allow people to determine what is going to be covered and what's not going to be covered, and for doctors to have that sense as well, and for patients that can help them make determinations of what types of coverage they want to purchase. As for what types of care they apply to, it's really all over the map. I do think initially, and we're still piecing this together, but I think initially they evolved more with, you had a categorical coverage exclusion. So maybe we don't cover obesity services at all. We don't cover obesity surgery at all. And then there was a recognition, gee, we can't just categorically exclude this, but some people really need it. So then there was sort of an exception built into it for, okay, if you meet these certain criteria. I think over time, and so I think that initially they involved things that maybe, you could predict a little bit ahead of time. Like maybe you could predict ahead of time when you're shopping for health insurance, whether or not you might want coverage that would cover, surgical responses to obesity. But I think what's happened, especially with the sort of all-encompassing incorporation by reference of medical policies, is that it's become everything. And because it's become everything, that almost undermines the ability, the sense in which you can get any meaningful information. I mean, I think it's really unlikely that anyone's shopping for health insurance and looking at medical policies by and large, unless they have some really specific condition. And in that case, I think it can be valuable, which is why I don't think, our answer is there was no solution there that said prohibit insurers from using rules of medical necessity. Because I actually think it's a good development that we have them, as long as we use them in the right way. And so if you're using them to make initial claims determinations, okay, well, then if I'm shopping and I see, okay, well, I have XYZ condition, and I want to make sure that my insurer is going to cover my condition and deem it medically necessary, I can look at their rules of medical necessity, determine that they're going to cover it, and then be very confident that it's going to remain that way. So I think that's the benefit. I think the problem is just when these rules are actually then used in a way that undermines any essential scrutiny of them. And that's the concern. Does that answer the question? Okay.
Thanks.
I don't see any other hands up.
Oh, mine's up, and
Okay.
John Cogan's is up, and Michael Abram, what's up?
Oh, okay. Oh, there we go. Okay, now I see. Got it. Oh, and well, now I guess I guess I have to call on you, Peter, because you told me that your hands up.
You don't have to.
I will.
Okay, so what I loved about this was, especially at the end, you were very honest, and you didn't try to oversell your solutions, and you acknowledged the problems with all of them. And so I feel a little reluctant to press you for more crispness when the situation just doesn't really allow for that. But it seems to me that you're kind of ducking the really hard question. As hard as those questions were about what we should do, the real question is, what should we cover? And who is in the best position to decide what we should cover? And it seems like you just don't really have anything to say about that. So what should we cover? Like, how are we supposed to figure out as a society, what should we cover? And that to answer that question then gets you to the, all right, then which institution or person or body is best suited to do that? There's no particular reason to think that insurance companies will choose that correctly. They have their motives, but there's no reason to think that lawyers or policyholders or anybody else will choose it correctly either. So how do we even know what we're trying to characterize as a good solution to this problem?
Well, Peter, I think the answer is clearly government death panels. This is okay. There's a reason why we duck this question, because it's such a hard question, and in a sense, our main point, and I do think we have to make this more clear. This is the first draft, and I absolutely think we need to make this more clear. Our main point is simply health insurers should not be allowed to make this decision without second guessing, right? Like, that's our point, right? And that's the system we've gotten to. We've gotten to a place where health insurers have figured out a way to make these determinations on their own with essentially no institutional second guessing because of their rulification of medical necessity. And that is not good. How should we do it? I don't know. I mean, maybe we should do it by letting health insurers have the first cut at it and then having other people second guess it. Maybe we should just say, let's do what the Medicare does. I mean, I'd be okay with that. Let's let the government decide and weigh costs and benefits and so forth. I think I'd be okay with that. I don't know if that's politically palatable. A lot of people would not be okay with it. Maybe the answer is to delegate it to doctors, but obviously they're going to have their biases too, and I certainly think that doctors are going to want to cover too many things. So I don't have an answer, but I think for our purposes, the key thing we have to make clearer, and I think the only thing I really need to say to your answer is that the solution is not to let health insurers make that decision without any second guessing. And that has to be much more upfront in the paper, but I think that it's enough to get us where we need to go. So thanks for that question. John.
Hi, Dan. I just have a quick question and a quick comment. Thanks for sending the paper. And if you talked about this at the beginning, I came in a few minutes late. But there's a lot of data, or at least some data, on the success of appeals, first level appeals, second level. And my question is, and I'm sorry if you talked about this, but have you seen appeal rates start to go down? Because in the past, it's sort of hovered around 50-ish%, anyway from 40 to 60%. Has it started to go down? Because I think that would at least raise the concern of insurance regulators if all of a sudden it turned out that everybody was losing on appeal. And the second thing I have to say is a quick comment. I actually like your solution. I'm not so because for a practical reason, or practical reasons. But the one thing that you might want to be to consider is there's this famous sort of controversy over high dose chemotherapy and bone marrow transplant for women with breast cancer. And there's a perfect example of where relying on the courts just completely wrecked everything, right? So if you're going to propose that solution, I think you need to at least acknowledge that particular, and there's a string of law review articles on it. I'm sure you know well about it. So that's my only comment and my question.
Yeah, so let me start with the second point first, which is much easier. So we have a whole section on that in the paper. And actually,
and thanks for sending the paper. I haven't.
No worries. So that's actually where this all started, interestingly enough. And the way we frame it in the paper is actually there were a bunch of scholars, very good scholars like Mark Hall and Bill Sage and some other really top-notch scholars who basically in the 90s suggested that health insurers should adopt rules of medical necessity in their insurance policies to limit the power of runaway courts, because pretty much everyone agreed with your assessment that courts got it wrong with high dose chemotherapy for breast cancer, and so the solution was rulification. So we acknowledged that very early on in the paper, and our argument is essentially that's fine, but the problem is that rulification has also undermined all the other checks as well. And so we've gotten to the point where the solution that was suggested has sort of overshot the mark, and has gotten to the point where we have no checks. And that's why I'm hesitant to say the solution should be, that's why like one of our solutions was ban, well, I guess this, this is a point against the solution to ban rules of medical necessity in litigation, because it's very clear that courts, are going to be overly sympathetic to people who want health insurance, and they're not very well situated to get it right. So I think that's a problem with that solution. And so we try to acknowledge that, but I think your point is we could do a better job of acknowledging that's one downside of our potential solution and my favorite solution. Your first point is actually a really good one that we have the data on, we were looking on, but we haven't really delved into it. The thing that's very clear from the data that we've looked at is basically there are very, very few appeals. I mean, it's remarkable how infrequently people appeal health insurance coverage denials. And what we haven't looked at is trends over time. It'd be great if we could see a trend over time of decreased appeals and then somehow link it to rules of medical necessity. I don't think we're at all there yet, right? Like, I think that would be very speculative on our part. But I do think that we might be able to enhance our story by talking a little bit about what that data shows in terms of rates of appeal and in terms of success. The difficulty is that the landscape is very much changing. So it's hard to know, again, there are plenty of policies that don't have rules of medical necessity or that don't have it for many types of care. And we're not going to be able to match the complaint data with information about insurance policies and whether they had these rules. And that's really what we'd want to do to be able to leverage it in a way that you suggest. But I think it's a good suggestion and we will definitely think more about it. So thanks. Let's see, Michael.
Hi, great presentation, incredibly interesting and persuasive, I think as well. But still, I'm going to try to push back on the thesis a little bit. So in the literature on mandated disclosure, there are certainly some people, Omri Ben Shahar and Carl Schneider, for example, have this book called More Than You Wanted to Know, which, it's essentially, I think, takes the position that really the whole thing is that all disclosure is basically a failure. And you don't really need it for a lot of consumer contracts with things like Verizon or something, because consumers have at least an approximate sense of how lousy Verizon is and how much time they're going to spend on hold and that kind of thing that they hear from their friends, and they can look at ratings and things of that sort. And so that really you don't need much in the way of contractual protection. And so one might imagine the same thing might be true in the context of insurance as well, if consumers have some idea, well, USAA, they tend to pay out, they're pretty reasonable and so forth. And maybe you wouldn't need rulification of anything, but you could also just allow a lot of discretion, right? I mean, you could just eliminate the court's ability to kind of second guess, and I mean, really, to some extent, eliminate the ability to enforce contracts, to contractual coverage terms, and let the insurers decide. Now, I think your answer to that would be, well, consumers don't have good information. But if that's the case, might there be, things that we could do that might focus on that problem? So, some kind of government role, for example, and not in producing these detailed, 500-page disclosures, but in, something like a nutrition fact kind of just saying, how long do people live, on this insurance, given this health insurance, controlling for, existing condition and things like that. Could we do better with that than with this kind of game where insurers really don't see their goal as increasing longevity. I mean, I think this would be the argument for why we need some constraint. They just see it as their goal is maybe not paying if they can get away with it. You think that's the problem? I think contracts aren't the answer to me. Some kind of reputational mechanism might be better.
Yeah, so I think this is a fair, a criticism. It's not one I agree with, right? And the reason I don't agree with it is because I don't think people have the information, and I think it's not realistic to try to get that information. It's very hard to get that information, and people, even if they have that information, are going to irrationally discount it and focus on prices. But one of the things that we try to do is try not to tackle that. We try to sort of say, look, people are going to have their priors about these types of questions. Like, we're not going to resolve people's views about the appropriate role of government in health insurance and healthcare. Like, those are just larger questions. And what we want to do is alert people to the fact that this change in contract structure is altering the balance and the effect of law. And then there are a variety of solutions you can adopt based upon your priors about how much we need to constrain health insurers. So to some extent, it gets back to my response to Peter. And what your question poses is maybe we're actually not that concerned about health insurers making these decisions about what's covered and what's not, so long as their reputations reflect those decisions. And so maybe we could facilitate that. And basically, that's what we're imagining in that sort of category of, I went through it quickly and said, I don't believe this is really helpful. But, for someone who is subscribed to that theory, I think the sort of, last solution we have of more a transparency-oriented reforms would be attractive. And, I'm very familiar with, the Omri's book. And I think, while I basically agree that many disclosures don't work, I also think he's a little too pessimistic and, all disclosure is pointless. No, I don't think that's true. I think some disclosure rules work reasonably well. And certainly if you design them, they can work well. And so maybe we could do things like, actually, Russell Korobkin has this great paper from like 15 years ago about basically, and I think we need to do a better job of incorporating, but basically, setting like, almost like metal tiers, like, quality 1, quality 2, quality 3, quality 4. And you could imagine the government, say, having like 5 different versions of rules of medical necessity. Like the gold, we cover everything that could plausibly be helpful. And we always err on the side versus the, whatever, tin, right? Like, basically, we only cover things that are absolutely perfectly clearly medically necessary. If there's ever a question, we don't cover it. And then we basically allow insurers to adopt a 1 through 5, and it's all standardized. To some extent, actually, that's even how we deal with Medicare supplement policies, where there are like 5 or 6 different standardized versions. That would then involve the government coming up with like 5 or 6 different versions of medical rules of medical necessity, and insurers coordinating around them. And I think you would need something like that. I tend to be much more receptive to market-oriented strategies if you have standardization and like a few clear tiers where people are making trade-offs. I mean, at the end of the day, though, I'm going to go back to what I said to Peter. I don't think the answer is to have health insurers making these decisions with no second guessing, where their decisions are, try to read these medical policies and characterize them. They're thousands of pages long. They're incredibly complicated. No one even understands what they are. You have to be a doctor to understand what they say. And so right now we don't have any mechanism. Could that work if we believe that, people could? I could imagine that being a solution.
So one of the great things about doing this on the web, of course, is you don't excuse you or call time. Just drop out of the conversation anytime you want to. But I think we've kept Dan for more than the hour that he said he was going to give us. It's now 5:04. There's still some people in the queue, and if Dan, you're willing to stick around to talk to them, that would be great. Anyone else is welcome to stick around too. You're also free to leave, but I just want you to join me in thanking Dan for exploring this incredibly complicated issue. So,
thanks so much. I really appreciate it. And I definitely will stick around and answer any questions.
Thanks, Dan.
Yeah, absolutely.